Hello, 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 everyone. Welcome, welcome, welcome. We are so glad that you are here because we have Norma Williams back with us, and she is going to talk about due diligence and some really important things for you to do that she could also do. And I just want to read this I like to find a little something that works with who our speaker is. So, and of course, I have to wear glasses now. The ability to attain our goals, to control our experiences, and have them result in happiness, prosperity, and success lies within our own thinking and the way we use it. Betty Simmons, Coaching Magic. And today we have wonderful Norma Williams, who is a principal of Williams and Associates, a commercial real estate law firm based in Los Angeles. The firm's real estate practice focuses on financing, purchase, and sale, and leasing transactions. Representation involves almost every commercial real estate property type, including retail sites, office complexes, raw land, multifamily housing, manufacturing facilities, industrial properties, entertainment venues, and others. Clients have included real estate developers, high net worth individuals, financial institutions, public agencies, office, industrial, and retail shopping center owners, grocery and restaurant chains, entrepreneurs, and many others. Prior to starting her firm, Ms. Williams practiced with large firms including Reed Smith, Arthur and Hayden, Hannah and Morton, and she's practiced in-house with a major bank. Ms. Williams has been named a Southern California super lawyer, yay, for each year from 2006 to 2023. Congratulations. Ms. Williams received her JD degree from UC Berkeley School of Law. She received her BA degree magna cum laude from Wesleyan University in Middletown, Connecticut, where she was also elected to Phi Beta Kappa. So Norma, we are so excited to have you here today.
Thank you.
Take it away.
Thank you. Happy to be here and see everyone.
We're thrilled to have you.
Thank you. So I have a PowerPoint to share. And as Peggy said, I'm going to be going through a presentation on due diligence. And actually, I think I prefer this one for going through the presentation. Stages of a commercial real estate transaction, acquisition transaction with emphasis on due diligence. So as I mentioned with the previous presentation that I did, this is not the kind of thing that you will be focusing on in particular, for the deals you invest in, for Peggy's deals that you invest in, because that's what they'll be doing. But in your own transactions, this is what you'll be doing if you are, directly involved in purchasing a property. So the first three stages of a transaction, locating the property, negotiating the basic terms, and generating the letter of intent are things that in the deals that I work on are generally more done by brokers. Sometimes with clients, if they're less sophisticated, I'll ask to be involved in the negotiation or the letter of intent. But with most of the deals, 1 through 3 are handled by brokers, and I come in at the point of negotiating and documenting the purchase and sale agreement. The client is actually involved with opening the escrow. And then after the transaction is in escrow, then you go through a phase of due diligence where basically, the buyer is determining whether or not to buy. And after that is all sorted out, and I'll be talking about what that means, you'll be going to closing. So the due diligence requirements in general, everything pretty much has to be done within a certain time period. They're not all the same. I mean, you may have 30 days for title, 30 days for inspection, but a lesser period or a greater period for other due diligence. Generally there is evaluation that's made, and the the buyer identifies defects, and then you're on to trying to cure them. So the first thing to think about is, how you obtain information. And there are many ways. Probably the first way that you would get information as a prospective buyer is from the seller. The seller would be obligated to turn over to you everything that they have in their possession that's relevant to the property. Sometimes this is even done, this is specified in a letter of intent. The seller in general in California, and I think probably in other places, even if it's not in the purchase and sale agreement, there's a duty of a seller to disclose anything that is material that might affect the seller's, the buyer's willingness to go forward. But probably the larger source of obtaining information is just, getting reports from other professionals, title companies, surveyors, et cetera. Purchase and sale agreements commonly require that the information that the buyer gathers be confidential. This is, seller's concern that it not everything that they find out not be disclosed. And then in many cases, the buyer is obligated, even if it doesn't go forward with the sale, to share with the seller any reports that they obtained. And this is something, that can be negotiated. But a lot of times I'll say the seller doesn't want the reports because, again, if they have them, then they have to disclose what is in them. So in terms of the types of due diligence, there's physical inspection, there's title, there's survey, there's environmental, there's ability to conduct, and I'll be going through each of these, ability to conduct business or to use the property for a specific purpose. The prospective buyer will be looking at leases, they'll be looking at service contracts, and, depending on the property, there might be other things that are relevant to that particular that particular property, that particular transaction. And if there's financing involved, the lender will be doing all the same due diligence. Usually it's, completely separate. I mean, I don't usually compare notes, but the lender will be doing the same due diligence. So in terms of title due diligence, the starting point for title due diligence is to get something which is sometimes called a preliminary title report. Sometimes it's called a commitment. And what does it tell you? A lot of people, think that a title report tells you who's on title, which is, who owns it. But that's, the smallest amount, or a small amount of what the title report does. It does tell you who owns it. That's called a vesting. It's usually, up towards the beginning. And so it tells you, whether the person who's selling to you is the owner. Reports now are what's, as you will know this, hyperlinked, so that if you click on the vesting, you should get a copy of the latest grant deed that shows, how your seller obtained title. But the title report tells you a lot more than just who is in title. So the sections of the preliminary title report, there's a legal description, there are sort of exceptions, which are the main thing that you're concerned about. There are sort of the standard exclusions and exceptions. And then if there are any unique requirements of the title company, like, they want the ownership documents of the seller, they want certain information, that will be there. So form of policy is a little bit, I don't want to get too much into the weeds, but there are a number of different title products that title companies issue. They issue a homeowner's policy. They issue, in California, there's a standard coverage policy. There's an extended owner's policy. And I think in commercial transactions, the main ones that you would be looking at are either the standard coverage policy or the ALTA, American Land Title Association extended coverage policy. And the difference between these is that the standard coverage policies generally only will disclose what is of record. So in other words, what's in recorded documents. And so it won't tell you things that are off record. For example, rights of tenants in possession, or encroachments, or discrepancies, or conflicts and boundary lines, things like, you don't go down the recorder's office to find this out. So if you want that kind of information, you have to get an ALTA extended coverage policy, for which they will require an inspection so that they can determine all these off-record things. They'll require a survey. So, but going on number 4, the most important thing that any title commitment or report tells you are the exceptions, which basically it's everything that affects the property. I won't say affects title, but affects the property. So it shows easements, it shows liens, it shows any restrictions. It shows, I mean, it can be anything. It can be leases, it can be other mortgages. And so the kind of the exercise that buyers go through, and all of these are hyperlinked. So if you click on any one of them, you can get the full document. It used to be when I started practice, you waited for the title company to deliver you the paper documents. And it was like, did we get the documents yet? Or you'd get something that was originally, done in 1930 and it was on black paper with white handwriting. And it's like, I can't read it. But now everything is just hyperlinked. You just click and you get the full document. And I can't say enough, like read everything, like read all of it, or have someone read all of it for you, because it's, the worst thing that happens, I think, when people don't, comprehensively review title is they assume that stuff is boilerplate or doesn't matter, but it does. So, so what do you do about exceptions? Basically, you go through and you see what issues there are. I mean, with easements, you want to know, well, I guess the other thing you say is that you should also ask title companies for a plotted easements map so that you can see physically where the easements are, even if you don't get a survey. But in general, what you do about exceptions is you just go through them one by one and you say, this stays on, this goes away. So for example, with monetary encumbrances, if your seller has a deed of trust, I mean, obviously you're going to get that taken off because you don't want to close with that, your seller's loan on the property. But you want to go through, if there are restrictions, if you're buying something in a shopping center and, it turns out that there are restrictions, you need to read those because it may affect your development. And so what ends up happening, I'll talk about endorsements later, what ends up happening, number 7, is that representing the buyer, you write a letter addressed to the seller and to the title company saying, this stays on, this is approved, this is disapproved. And in addition, you would specify the endorsements that you want. So endorsements are sort of items that offer additional coverage to the basic coverage that you get under the policy and relate to unique exceptions that are shown on the property. So for example, if there's a covenant or a restrictive covenant on a property and you want to be sure that there's no violation of that might later result in you having to, take down a building or move. I mean, that's like the 100 endorsement. Or if you're buying a property that's 2 lots, 2 legal lots, you want to get like a contiguity endorsement that assures that there's a common boundary. If it's a condominium, you want to be sure, you want to get an endorsement that says that the condominium was and the common area were validly executed. There are no present violations. So endorsements, I mean, I could go on and on because there are like 100 standard endorsements, and a lot of title companies all have their own endorsements. But basically, endorsements offer basic, coverage in addition to the basic coverage of the policy. And then after you send in the title objections cure letter, generally the purchase sale agreement says, the buyer has to send their objections within a certain period of time, and the seller has a certain amount of time to say whether they'll cure or not. And if they won't cure, then the buyer has a certain amount of time to say, well, I'll buy anyway, or I won't buy, the deal's off, and they get back their deposit. And so, that's kind of an important exercise, but an important process. Sometimes things, dates have to get extended or whatever. And then what is requested, either right after that process or more generally up until closing, is that the buyer would ask the title insurance company for what's called a pro forma policy, which is exactly what the policy will look like, including all the endorsements, including, taking out everything you said to take it, the buyer said to take out, because, you don't want to get to closing and get a surprise. And so that's a pro forma policy that you want prior to closing, and then you get the policy itself. So I think next is survey review, and not every transaction has a survey. And I actually wanted to open up to you, Peggy, and ask how often, do you usually get surveys? Depends. A lot of it, as I mentioned, depends on the form of policy. As I mentioned before, the standard coverage policy, which only covers things of record, will exclude everything, things that a survey would show. But if you want the ALTA extended, the title company is going to ask for a survey. So surveys have to be done in accordance with certain standards. There's standards of a group called American Land Title Association and the National Society of Professional Surveyors, and they update their standards every couple of years. But basically, there are mandatory standards, minimum standards that have to be in every survey. It has to show the boundaries. It has to show that they reviewed records. It has to show that they did, they actually went out to the field. And then there are certain optional coverages that are not in every survey. But for example, lenders, like when I represent lenders, and they want surveys, which they usually do because they want extended coverage policies. I always ask, well, what Schedule A items do you want? And so the Schedule A items are kind of additional things that a lender or anybody might want shown on a survey. So for example, they may want, the zoning, they may want to know the flood zone classification. Basically, there are 20 optional survey items. And so you just, write to the surveyor and say, I want the number, detail on the number and type of parking at the property. So, governmental agencies have specific survey requirements. But anyway, so there are the basic standards, and then there are the Schedule A standards. The relationship to review of title is that, normally, that review letter that I mentioned will be title and survey, but you want to be sure that all the easements, for example, that are shown on title are shown on the survey. And you just generally want to, just sync them. And there are certain things that require syncing with title, but there are also things, as you will probably have had experience, that have shown up on surveys that aren't on title, but are problematic. For example, if you find an encroachment, where the building encroaches on an easement, or something's over the boundary line, or they go out and inspect and they find that a neighbor has had an easement created by adverse possession. And so there are some things that, the seller can and will do things about. There are some things they won't, but there are also reasons, depending on what you find, that might cause you to, walk away from a transaction based on the survey. So, but the bottom line with a survey is that, they're not necessarily required in every transaction, but most lenders will require them to get an extended coverage policy. So the next type of due diligence is environmental. And I think you all have probably gone through all of this that I'm talking about, but this phase one environmental site assessment, people just call it a phase one report. It is, there's standards for it that are promulgated by a group called ASTM, so American Society for Testing of Materials. And generally the phase one, shows current and historical uses of the property. They, just go back over old photos, they go back over historical records, and they, and what they're looking for is any what are called RECs, recognized environmental conditions. And these will be identified in the report. And I just, when I get a phase one, what I do first is go to the executive summary, because it's like, oh my God, is there a problem or isn't there? And only if there's, an issue will I, kind of drill down into the report. But that's kind of, well, I guess I always do, but that's kind of the first thing, is to look at the executive summary. And then they make recommendations, which basically, no further action, or they recommend that because of the RECs that there be further investigations. And that's when you have a phase two. And the phase two generally involves just investigating more with, taking samples, testing the samples, doing analysis, drilling. So it's much more invasive. And like in a lot of purchase and sale agreements, sellers will say, go ahead and do the phase 1, but you can't do the phase 2 without giving me a copy of the phase 1, seeing if, my expert agrees that a phase 2 is necessary. And, you get into an agreement about having an adequate insurance and, making sure that the people who are going out have adequate insurance and indemnities and so on. And so, and of course, usually either the seller or there might be termination rights where if either finds that a phase 2 is necessary, the seller may say, they don't want to permit. I've had situations where you had to get permission to do a phase 2. But anyway, if the phase 2 in further investigation finds that remediation is actually done, then that's, a whole nother discussion in terms of whether the buyer wants to stay in the deal, whether the seller is going to permit it, et cetera. So I think the next to the last thing that I'm going to talk about is, it's not the next sentence. Anyway, ability to conduct business. And so a lot of times, the buyer's willingness to go forward with the transaction will be dependent on whether it is able to get the permissions that it needs, whether it can get building permits, whether it can get the appropriate zoning. And so they are given a period of time, a due diligence period, to try to get these approvals. It's from governmental agencies, and it might have to do with, use, design, landscape design, signage, the site plan, et cetera. And so, some of the key features of this type of the provision in the purchase agreement that addresses this are that, the seller has to cooperate, right? Because nobody has to talk to the buyer. They're not entitled. The purchase agreement would usually say that no approval is binding on the property or the seller if the transaction doesn't close. It's also common for, because of governmental agency delays, for there to be in the purchase agreement the ability of the buyer to get an extended approval period. Sometimes the buyer has to forfeit some of the earnest money in that case. But anyway, it's very important to, for the buyer to know that if they go through with the deal, that they will be able to use the property as they need to. Usually, a lot of times these go to the government requirements, but they also might be requirements of private party documents. Like, if in a shopping center, there may have been an agreement by the original owners or later owners that only certain type of new uses can come in. So anyway, that's ability to conduct business. The next due diligence is lease due diligence. The greatest significance of the review, this is you're buying and the property that you're buying has tenants, is obviously that, the income stream and, the rent roll is one basic document that you just have to have, in general for debt service if you have a loan. But I think that, it's very important, again, to review all the leases because, you may find out that tenants have early termination rights, or you may find out that, they have rights to terminate if an anchor tenant leaves, or just other, provisions. You may find that you have to pay brokers' commissions if you later sell or later rent. So it's just very important to read all the leases as well. The other thing that is as part of lease due diligence is to be sure that the leases have estoppel certificate requirements, which require the tenant to tell you, the prospective buyer, if there are any, if they claim there are any defaults of the landlord or any, defects in the property. And then the other thing that you'll find with lease review is what kind of rights, what kind of recognition the tenants want from lenders, that if they are not in default, and even if they foreclose, the lender will allow the tenant to stay in place. And the last area is service contracts. And so these are the contracts that might be on a property that you're buying that have to do with, elevator maintenance or parking lot, the person who guards the parking lot or maintenance or security or landscaping. And so these are these contracts are usually pretty flexible in terms of, what a buyer might anticipate. Many of them, I mean, I remember, doing things for, like, if you're doing a large building and have to review a lot of service contracts. I mean, a lot of them will just straight out say they terminate upon the sale of the property. So in that way, the new buyer's not bound. They can bring in their own crew or whatever they want to do. Sometimes they, require 30 days notice, but they're generally pretty flexible. I mean, you don't usually hear people getting stuck with, service contracts that they don't want. So, let's see. So then in terms of what comes next, as I said, this is all about communication, just back and forth, this is fine, this isn't fine, fix this, do this. I mean, it's just a lot of communication. The important thing also is, just getting items cured. And sometimes you renegotiate different provisions, but the goal is at the end of this due diligence period, the buyer is ready to say, I'm ready to go forward, or I'm not going to go forward. I'm terminating the transaction. Give me back my earnest money deposit. And that's why that's a very important phase of the overall transaction. When that process is finished, end of the due diligence period, you're off to closing and doing all the things that you need to move forward with the closing of the transaction. So that's it.
Thank you, Norma. That was fabulous.
Oh, thank you.
Really great. I do have a couple things that I wanted to ask or bring up. And so first I do have a question.
Okay.
So you said that you do an inspection, you hire an inspector, and the inspector brings in the inspection, and something shows up that the seller didn't disclose. You said the seller could say that they do not want to take the information because then they'll have to disclose, but don't they, particularly in California, by law, it's now been brought up, they have to disclose it. They can't refuse it, can they?
No, but what I'm saying is that if they know something, they have to disclose it.
Right.
But sometimes they may not know something, but if there was an inspection, then they would know it. And so they may say, before they see it, say, I don't want the inspection report. I don't want, it happens a lot with environmental, right?
Oh.
But it's once they know, they have to disclose. So sometimes they don't want to know.
Got it. Because that was one of my comments was everybody I've ever talked to that's, in commercial doing an environmental phase one, they're like, we got our fingers crossed that it's only phase one. Because that's like $10,000. And from there, it can go up to six figures and more.
Yeah, it just depends on what's wrong, what's identified.
Exactly. And what they're planning to do.
Right.
A lot has to do with what they're planning to do. So that there was that. So in other states where we have purchased properties, surveys are required as part of the process. It's not like you have a choice. In California, even though we on our own homes, we order an ALTA policy. We've never been required to have a survey. When you're in a standard home, they still come out and look. Like where I live, there's an easement and it's coming across somebody else's home for the driveway. So they're standing in the driveway going, where's the easement? And I'm like, you're standing on it. Hello, that's somebody else's house, and this driveway goes by their house to get to mine. It's really quite funny, actually, when somebody asks where the easement is. Okay.
Interesting.
So,
I didn't know that in other states you have to have surveys.
Yeah, that was in Georgia, actually. One of them was in Georgia, and one of them was in Virginia, where they required this. And so what do you want to do? You want to save money. So I'm like, okay, who was the surveyor who did this survey last?
Right.
Because they won't charge you a full survey. They'll pull their old survey and then They, like you said, they change things over the years, so they just go out and walk the property, remeasure it, and make sure everything's copacetic like that, so.
Yeah.
Yeah, very interesting, getting a policy. It seems so simple, but when you hit commercial, it can be just so different, particularly if you're doing a conditional use permit or
Mhm.
a change zoning.
Yeah,
Like-
title is can be very complicated, just
I bet you've been through a few.
yeah.
Does anyone have a question or a comment? Yes, Ted.
What issues have you seen come up that date back to before civil, let's say before the country was thoroughly civilized?
When was that? I mean, what time period? I'm not sure. And in
Well, in
California,
California, it'd
it'd
be probably early
1849.
1800s.
What are you
Um,
asking, Ted?
So what issues or case studies has she seen come up involving, let's say, problems that date back to before our current civilization?
I don't think anything's going to show up like that that hasn't already been handled.
Well, I don't know that it would be of record. I mean, I think, yeah, I'm not sure what that means. I mean,
Well,
I
in some
think,
parts
say,
of the
for
country that
example,
were
Indian.
dominated by Native Americans.
Well, that was just what I was about to say. The Native American land rights, I think, have been pretty much extinguished except in reservation land. I'm not even sure about that. I mean, Indian law as a whole, but I mean, I don't think that, most of the transactions that we work on are, I mean, maybe you have, burial grounds and, whether those should be protected.
The turtle, what about the turtle or in saving the whatever animal?
Mhm.
Do you
Yeah.
come across any of that?
Yeah. Yeah, it's more, well, actually I don't see it a lot in title. I think land use people see that. I mean, people who are dealing with actual development, people who, representing people who are buying land for development, which is not what I do. But yeah, endangered species, there's a whole Endangered Species Act that, has to be considered. It's not something that I generally get into.
Mm-hmm.
It was so funny. I was reading something earlier today about how water rights sometimes comes up in, let's see, I don't know, there's certain rights that the federal government retains based on the federal, well, that's sort of different. The federal government, under the Commerce Clause, retained a navigable servitude over all waters that are presently, have been in the past, or may be in the future susceptible to use for purposes of interstate or foreign commerce. Anyway, yeah, not too much. That's an interesting question. It probably goes back farther in other states, than California.
Yeah, Jonna.
Norma, thanks for running through the due diligence. And you touched base on how many of us are investors, not necessarily doing this due diligence, but given your knowledge on this, what questions should we be asking operators?
Mm-hmm. You mean in connection with their acquiring property?
Yeah.
What are they doing? I mean, yeah, just ask them how they conduct due diligence, like kind of what's their process and title review, what do they do, and all of the things that I mentioned. Yeah, I mean, some people have checklists and is it, do you go through all this? But yeah, it's very important to know that the people who you are investing with have done this in connection with the property that you're investing in or the fund that you're investing in. So broadly, I would say that they should be doing everything I just talked about, right? And just, but if it's in the form of a question, it's kind of, how do you conduct due diligence? Just, what do you do? And there may be, um, guidelines that they have. Yeah, I mean, it's a good question, but I think bottom line is you should know that they're doing all of this accurately and they're not, relying on, people who may not have as much expertise or, you should just know that they're thoroughly conducting due diligence. I mean,
And then if you were a significant investor, would you want to see the reports?
Yeah, I think I would. You don't want to get in a, position of, necessarily slowing down the deals, given that they all have time deadlines. But I think that's a reasonable request. Peggy, what do you think?
I think that you should look at everything and make sure that you don't have any questions about it.
Mm-hmm.
Read the documents. You got the documents. They should be read either by
Mhm.
you or your attorney or one of your partners.
Mm-hmm. Yeah, and I don't know if
And you can always put your hand up using the reactions. That will help. I'll catch you that way. Do you have another question, Jonna?
No, I don't. Thank you.
Okay, Ted.
What sorts of issues do you see coming up, let's say resulting from natural disasters, especially in California, fires, landslides, earthquakes, that sort of thing?
Yeah, well, I mean, a lot of things will, I mean, California has a requirement that the buyer be given a natural hazards disclosure. So I think those will be looked at very carefully. I think that, physical inspection reports will, have to really look at the effect of earthquake damage. I mean, yeah, it's trying to think fire.
Well, what about like a landslide? Like right now, we're having all these rain.
Oh yeah, that's right. And Rolling Hills Estates.
I mean, we see it on the streets all the time, but the government handles that. But what if it's somebody's yard now in your yard?
Yeah.
How does that get handled?
Yeah, you're right. I mean, in Palos Verdes has been all over the news lately. It's, beautiful, but I mean, you just have houses sliding down hillsides and, so I think, well, it's certainly a disclosure obligation on the part of the seller. I mean, I think that, buyers may, refuse to go forward with transactions. But you're also going to have lenders, lenders who are just not going to lend, insurance companies that aren't going to insure. So, I mean, it can be, catastrophic. I mean, what's happening here? I mean, it can really affect transactions and, I'm not really sure in terms of the surveying standards, how they, for example, if there's a, as Peggy said, your lot is now in my lot, it probably still should not affect the property line, but, maybe that, more, I mean, if I were, a lender or anyone looking at survey, I'd probably, think more about getting some of these, optional survey items. So, for example, well, certainly flood zone classification, gross land area, who knows if that'll be, yeah, no, there's a lot. I mean, there's a lot to think about. If evidence of, recent earth moving work, building construction. There's an article there. There's several articles in what you just said. So, but yeah, I see a lot. I mean, it's pretty significant.
Thanks for the question, Ted.
Yeah.
David, what you got for us today?
Yeah, hi, this is a good topic. Can you hear me okay?
Yep.
Great, I'm in the car. So I had a question reference to the environmental reports and some of the things you just spoke about with the earth movement and so forth. Of course, perfect timing. So I guess what that entails, with environmental, I mean, the property at times has been, transferred a few times. And there's records of the prior
Uses.
Isn't there records that we can pick up from the past and so forth of environmental studies?
Yeah. They're in prior environmental studies, and plus, just from government sources, you can see the prior uses. When the land started being used as a gas station, what it was before it was a gas station. You're buying a property, then you may not be able to tell it just from what's going on now, but it may have once been a dry cleaners. And so you can figure all that out. And so the environmental consultants who do the reports, they look at past records, but they also do aerial photo. I mean, they look at photos from the past, which are also in the government offices. And so, you see a big vacant lot, it's a lot, and then 10 years later, you see something else on it, et cetera. So they, and all of that is, I had printed out phase 1 typically includes site visit, review of federal, state, tribal, and local regulatory databases, review of historical records such as historical aerial photographs, fire insurance maps, historical city directories, historical topographic maps, state and local records, building, fire, health, interviews with current and past property owners. So anyway, that's all in a phase 1. That's all, that and more is part of a phase 1.
Is that what you're looking for, David?
Yeah. I just going into the past and looking at some of the inspections that were done of the property at that time, and then you have to get yours just to verify. So I'm just kind of curious with your thoughts with that.
Yeah, I mean, as I mentioned, phase 1s, the standards for phase 1s are put out by ASTM and the Association of the American Society for Testing and Materials. And ASTM has standards for everything. I mean, they have standards for, glasses and whatever. But anyway, they have, and so if you're really curious, it's ASTM Standard Practice 1527-13, 1527-13 that says all of what's supposed to be in a phase 1 report. And it includes, those things that I mentioned, but, the important thing about a phase 1 is that it doesn't do anything invasive to the land itself. Like you don't drill, you don't touch the land, but you have all these historical records and, and if all of that leads you to think that there's a quote recognized environmental condition, that's when, the phase 1 would recommend a phase 2.
So if there was what you were saying, as you go back and you look and they see that there was a dry cleaner, maybe two owners back, does the environmental group look to see if something was done when the dry cleaner moved out to make sure the environmentals were done?
Yeah, they do. And you see that a lot with gas stations too. I mean, part of looking at fire department records is to see if tanks were removed, underground tanks were removed, to see if any remediation was required at a certain point. So, so you might find that It's interesting because I found this out this morning when I was preparing for this. So for example, I said that the goal in the phase one is to identify what's called RECs, right? Recognized environmental conditions. But but there's also something called a controlled recognized environmental condition, CREC, which it identifies that the property has been impacted by contamination, which has been investigated and remediated. So for example, if you are buying something that was a gas station, but the tanks were taken out, and the soil cleaned, then it's been remediated. And so that's a CREC, it's a controlled recognized environmental condition. So they identify that. And also, and then there's something called HREC, historical recognized environmental condition, identifies a release that impacted the subject property, which has been investigated and remediated, meeting unrestricted use criteria. So, it was a gas station, or dry, but it's been cleaned, remediated, and now you can, put a child care center on it. But I mean, that you can do anything that you want with it. So, yeah, and that's all in the public records. And so environmental reports can be, quite extensive. I mean, yeah, phase ones can be quite extensive depending on the project.
But if there's already one on file, don't they file that with the property? Doesn't the environmental get recorded?
No, I don't think so. I think that you have to find in the records, like at the fire department or whatever agency oversaw the remediation. But it wouldn't be I don't think it would be in the prelim, in the title report.
An environmental that somebody paid $10,000 or more for wouldn't be recorded on the property?
Mm-mm.
No. Interesting. Why not?
Well, it doesn't affect, I mean, how does it affect like the ownership or encumbrance or, I mean, so why not record that, there was an earthquake, or why not record that there was, I mean, the title report isn't to show physical condition, right?
Right, but the next time it gets sold, they have to do another entitle. They have to go through the whole thing again. Or don't they?
They do. Well, I mean, a buyer would want to, and in order to have like the benefit of innocent landowner defense, they'd have to show that they investigated. So yeah, the next buyer, if they were prudent, would have another report. But it's not, I mean, like most phase ones, like if you read, the very end of a phase one report, the consultant who does the report is really clear about who has the right to rely on that. And so they say, the prospective purchaser, their lender, may designate certain affiliates or owners are the only people who have the right to rely, because they don't want, if it's, a issue identified, but they were wrong, they don't want anybody in the world coming back and suing them and saying that this was, erroneous. And so, I mean, I've, negotiated who has the right to rely. I mean, just, that provision. And so, yeah, it's not something that would go of record.
Okay,
Yeah.
thank you. David, do you have another question? Okay, he's driving. Ted?
Is there anything in the real estate law that's equivalent to a holder in due course with financial instruments where the current holder is insulated from mistakes of the past?
I guess the closest thing I can think of like that would be like a bona fide purchaser for value, where there might be, bona fide purchaser for value without notice. So there's some issue with a property, but the, prospective purchaser didn't know about it, wasn't in collusion with the seller, paid full value, then, someone came against them and said, they said, but I was a bona fide purchaser for value without notice, as a defense.
that answer your question, Ted? Okay, great. David, I don't know if you're still there or not.
Yeah, I'm here. I'm good.
Okay.
You're good.
Thank you.
Okay, fine.
Thank
All
you.
right. Patricia, you're looking at different things. Do you have a question by any chance?
No, I'm really just soaking it in, and it's a little overwhelming.
Oh,
Well, that's why you hire someone like Ms. Williams. So
Yeah,
take care of the overwhelm because they've been through so much. It's
right.
just
She knows what
standard for
she's
them,
doing. I have no clue.
oh.
right?
Yeah. No, that's all I had.
So I have a question. Where are you all located? I don't even know where everyone is. I know
Oh.
Peggy's here in California.
Patricia's in Minnesota. Maria's in Brentwood. Lisa's in Northern California. Lisa Hernandez, Lisa Prince is in Georgia, I believe. And we're not sure whether we have Douglas here, whether we have Mr. Clark here. If it's Douglas, he's in Colorado. I don't know. Dylan, where are you?
I'm here,
What state are you in?
Houston, Texas.
Houston. And I don't know, Yanji? Where are you from? Mr. Chen, Miss Chen? All right. That
Okay.
person's not quite here with us today, so.
You have a lot of
Okay.
people on the phone, it seems like.
Oh, and David's California and he owns property in Florida. And Ted, you're in Illinois, correct?
Yeah, Chicago.
Yeah, Chicago, Illinois, and John is in Washington.
Hmm.
So you see why we do Zoom, because we are all over the place.
Right. Okay, thanks.
Yep, coast to coast, that's us. That's us. So yeah. So thank you very much for your great
Welcome.
presentation. It was really wonderful. Any last questions or comments for Norma? She's available. Did you put your information in the chat so people could get a
Oh,
hold of
okay.
you?
I will do
Yeah,
that.
would you do that?
Yeah,
That would be really great.
okay. Yeah.
Good.
Just-
Did you have any questions, Maria? You usually do have a question here and there. No, okay, good. That's
let
good.
me-
Norma, great presentation. Thank you very, very, very much. I hope you will come back again. You come up with some really great and creative information to supply our curious people on how to do better with their whatever they happen to be doing in real estate. So thank you so very much.
Okay, I'm just getting my information here.
Okay.
Okay, there we go. Yeah, I was looking for a signature on an email, but that's too hard to find.
Thank you.